Welcome to the Law Simplified's SQE Prep for Criminal Practice. I'm your instructor, Shaveen Bandadnayaka. This comprehensive program was designed to help you ace your solicitor's qualifying examinations. I hope you enjoy this course, but without much further ado, let's begin. Now, first and foremost, the reason why we start here, or the reason that we are referring to the individual, to the client that we are representing as the suspect, is because of the proverbial statement and the notion that you are innocent until proven guilty. Okay? So you will notice the terminology in this subject is very paramount to the study of this subject, and we never consider the person as, let's say, for instance, let's say the criminal. We don't refer to him as the assailant. We don't say any of that. We constantly refer to him, at least for about 2/3 of this until the appeals process, as a suspect. So the suspect is because this person has been brought before the police for questioning or other forms that we are going to go through, purely based on the fact that there is a sufficient quotient of evidence, or there's a sufficient quotient of suspicion that he may have been involved, or he was in fact the person who did it. But we are not privy to that information until much later. Are we good so far? Shall I proceed? Okay, so we start off by looking at the different rights of the suspect. The first and paramount of which is the fact that you have to inform whoever is being arrested that he so is being arrested and the causes of such arrest. Essentially, we are looking at the perspective here that a police officer is unable to arrest an individual unless a particular threshold of suspicion has been passed, unless there is some evidence that is needed, or rather that has been procured by the police officer or the investigating officer, that suggests that this individual has done something. Now, I must illustrate something here. We are only focusing on the practice components. The law of evidence is not something that is incorporated into your syllabus. So what goes into what amounts to sufficient suspicion and what evidence constitutes a sufficient requirement to arrest someone is not something that is in our purview. We don't care about that. We only care about the procedure after such suspicion has arisen and after a decision has been taken to arrest this person. Okay. Now you will see this particular statute. Let me change that color. This particular statute come up quite frequently. This is the Police and Criminal Evidence Act of 1984. Effectively, this is the Bible when it comes to criminal procedure. Handling of a suspect, handling of procedures in terms of gathering evidence, handling how exactly interrogations are supposed to happen, how arrests are to be conducted. Pretty much anything and everything that relates to the police's interaction with a suspect is dealt with here. In fact, it even has the rights of a solicitor in relation to the advice being given to a suspect, as well as his rights within a police station where his client is being interrogated. Now, at certain stages, we will also look at SRA regulations, the Solicitor's Regulatory Authority regulations, in terms of the conduct of the solicitor at a police station. We'll go to a very granular level. But whenever that's necessary, I will point to that. 90% of the time, it'll be PACE, right? The Police and Criminal Evidence Act. Yeah? Are we good? Shall I proceed?
Yes.
Okay. Now, there is quite a transparent mechanism that's in place when it comes to the arrest and detention of a suspect. starting from this point where when a person has been put into custody, has been taken into custody by the police, there is an obligation that the information, besides the reason for arrest, which is a different thing we will look at later, when a party has been arrested, there must be a transparent information, or there must be some information provided about that arrest to certain individuals pertinent to that suspect. So, for example, either a friend or some cohort, some person that has been with this individual, a relative, a parent, for example. We will look at children differently in terms of youth court later. Someone who is known to him if A and B are not possible, or someone who might be interested in this person's welfare. So I'll give you an example of each instance. So for example, let's say you have two friends, two tenants, two joint tenants, two bunkmates. One of them are arrested. The whereabouts of family or anyone else is unknown. Perhaps this person is from a foreign country. So you would inform the bunkmate, the other tenant, the joint tenant. If you are able to procure a relative or someone else, you would tell that person. It might even be the landlord, a person known to him. If none of those circumstances are possible, let's say in the event that this person is alone, he's living alone and is from a foreign country, for instance, there might be someone who is known to him even to a distance level. Let's say somewhere that he frequents often. Let's say a university student, his supervisor, his professor, someone of that caliber. There's a level of concentric circles that the police and the officer that has taken this person into custody has to look at, closest to the furthest away. But the furthest away would be someone who has an interest in his welfare. So in the context of a student studying abroad, hopefully not having friends, would essentially go to a professor or a supervisor. Clear so far? Are we good? Okay. Now, you'll notice there's a lot of procedure involved. So as a result, this context of custody, right? This aspect of custody, there are certain limitations that you need to look at. Now, the reason why I'm saying this is because when you generally take someone into custody, other than for an indictable offense, and now in the more modern context, anything other than a person taken under the Terrorism Act in England and Wales, the limitation for custody is 36 hours. Okay. Now, to go beyond that, in order to go beyond 36 hours, there are certain requisites that has to be fulfilled. I've stated the most pertinent requisites here. These are in relation to PACE, right? The Police and Criminal Evidence Act. But there are a number of other statutes that are interrelated to this. One of which that I mentioned is the Prevention of Terrorism Act, PTA. Those are not within our syllabus, and I'm particularly scoping these out because we have to be very mindful of what you're being examined on and what you're not being examined on. There's no point in going through everything and just overloading ourselves, because this is a fairly hefty subject. Yeah. Now, even in this case, even in relation to any of this, it's not automatic. This decision has to be preceded by an authorization provided by someone who is at a inspector or a higher level in terms of rank. So, for example, if we are to give a little bit of a context, you start with, let's say, constable, which is the lowest. Then you come to sergeant, then inspector, then chief inspector, then superintendent. So this cannot be a decision taken by a constable or a sergeant. It has to be an inspector, chief inspector, or higher up, or a superintendent. this requisite, right, this authorization point, you will notice in few other occasions that we are going to look at from now on. But keep in mind that hierarchy, at least informally. I haven't mentioned it here, but just for your information, the ranking of police officers in England and Wales and most jurisdictions would be constable, sergeant, inspector, chief inspector, superintendent, and so on. What's pertinent to us is only up to superintendent. Are we good? Questions?
Sure.
Yeah.
Okay, Kevin.
It's a right of the suspect to inform one of his closest friends or relative. So that has so can the police say no? We will inform on behalf of you, or the suspect has to be given the chance.
So
to
this
speak.
is what is famously seen as "I want my phone call." That's what this is.
Mhm.
So essentially, the suspect has to be given a right to inform
Oh.
pertinent people. Now, there is a thing like this, however. This phone call is the information that is being given is by and large limited to this group. Oops. Right? There is a reason for this. So I mentioned certain people, right? A friend, relative, person known to him. This is subject to a particular condition, which is that delay in informing someone and to keep in custody by and large even, right? We'll look at the custody bit later, but this informing of someone is limited if informing that individual will lead to interference with evidence or trying to tip off other people to escape, maybe like destruction of evidence itself or to move evidence. If any of these things are possible, so generally the determination of whether a suspect would do that or not might be based on his past record, or this investigation has been going on for such a long time, they know that this guy has a propensity to do this, or he has been either a suspect but never like convicted of anything, but he's been coming to police stations quite often as being part and parcel of certain nefarious activities. So if that suspicion is there, and it's likely that his informing someone would lead to other crimes happening or evidence related to the current crime being destroyed, then you can generally delay it. But again, delay, not prevent.